Will come to order. The clerk will call the roll.
Chair Moody,
Present.
Vice Chair Cook,
Here.
Representative Bajani,
Here.
Representative Bowers, Representative Darby, Representative Harrison,
Here.
Representative Leach,
Here.
Representative Christina Morales, Representative Schatzline.
Here. A quorum is present. Some housekeeping matters first. I apologize for those of you who have been waiting. The Committee on House Administration has approved a process for the electronic submission and posting of public comments for each item on today's agenda. The public comments submitted through the portal will be posted on the Electronic Legislative Information Systems, TLIS and TLO, as well as on the House website. At the conclusion of today's hearing, directions of how to submit public comments on the portal can be found on the meeting notice for this hearing. Today, the committee will hear from invited witnesses only. If you have not filled out a witness affirmation form already, please notify the clerk and we will remedy that problem. Due to capacity constraints in this hearing room, we have 2 overflow rooms set up for anyone present and wanting to watch the live stream of today's proceedings. Those rooms are E1014 and E1026. First and foremost, I want to thank everybody for being here. I apologize for the delay. As anyone who has been following this matter, there is an enormous amount of litigation around this topic. There's an enormous amount of conversation around this topic. And so many of us have been working through that. Did not mean to keep you waiting, and so please accept my apology for that. Today we have an impressive slate of witnesses who I think will surprise everyone and add important dimension to these issues. The most important witness, of course, is Robert Roberson. I'm very disappointed to say I don't believe that will happen today, and I'd like to go over why that is. As many are well aware, there's been a flurry of litigation in the Texas Supreme Court over the weekend. The upshot of that is that a valid legal subpoena for Robert remains in effect. If this committee wanted to take a heavy-handed approach, there are dramatic ways that we could enforce that subpoena. But we didn't issue the subpoena to create a constitutional crisis, and we aren't interested in escalating a division between branches of government. In fact, we have the greatest respect for every other facet of our government, and we want all of them to come together in our purpose here, which is making sure that Robert is heard. There's been a lot of discussion about video conferencing Robert in today. I believe that that'd be perfectly reasonable for most inmate witnesses. But Robert is a person with autism who has significant communication challenges, which was a core issue that impacted him at every stage of our justice system. He's also spent most of the last 2 decades alone, locked away from the modern technology we now take for granted. Video conference is poorly suited for Robert specifically to provide his testimony and would only further the harm he's already suffered. When I thought about the accommodations to be made, I considered his needs as a person with a disability above all other things. I also weighed the fact-finding needs of this committee, the entire purpose of the subpoena. Weighing those with the concerns that were outlined by the Attorney General, our committee simply cannot agree to video conference. That doesn't mean Robert won't testify at all. In the spirit of cooperation, we are in talks with the Attorney General's office right now about ways their position can be addressed while allowing our committee to hear Robert in person. I expect a quick resolution to these discussions, which are ongoing even at this moment, and I will update everyone as soon as those plans are finalized. At this time, I'd like to invite any member of the committee to make any opening remarks. Mr. Vice Chair. Chairman Leach.
Thank you, Chairman Moody, and thanks to those of you who are joining us here at the Capitol today, and to my fellow committee members, fellow legislators here in the room, to Texans who are watching on television, and welcome to all of the non-Texans who are tuned in across this country and really all over the world. We are honored to sit in front of you today and unlike Washington, to show you that government can work, and that Republicans and Democrats can work together, that death penalty supporters and death penalty opponents can work together, that the branches of government, the legislative, the executive, and the judicial branches can work together. When it comes to our fundamental duties as legislators, it's very simple: to protect at all costs the fundamental rights and liberties of the people, most importantly of which is the right to life. And when it comes to the life of a potentially innocent Texan, someone who I have, over the past several weeks, grown from having questions and concerns about to believing he is fully innocent, and was within 20 minutes and 20 steps of being executed by the state of Texas just days ago. If we can't speak up and step up and work together to fix a system that is not broken in and of itself, but that needs fix, that has failed Robert and failed Nikki, then what are we even doing? Today, this hearing, the purpose of this hearing, our purpose for coming together and issuing a subpoena to Mr. Roberson and to convening last week and today and in what is likely a subsequent hearing, is to ask questions and to find the truth, to figure out where the system went wrong, where it failed Nikki, where it failed Mr. Roberson, and to try to fix it, not only in his case, but to make sure that it never happens again. In closing, I'd like to make very clear, members and Mr. Chairman, remind ourselves that when we take our oath of office, we solemnly swear that we will faithfully execute the duties of our office of state representative of our state, the state of Texas, and will, to the best of our ability, preserve, protect, and defend the Constitution and laws of the United States and of the state of Texas. That oath of office I take seriously. I know each of you take seriously. And importantly, that oath of office is the same oath that judicial officers and executive officers take. And the legislative branch today is taking our oath seriously. And I'm honored to be here with our fellow members, and I welcome all the people tuned in to the Texas House of Representatives. Thanks for joining us today.
Chairman Darby.
Thank you, Mr. Chairman. First of all, thanks to the members of the committee for being here today, and thanks to the members of the public and other fellow members of the legislature that are sitting in the third row. I want to build on Vice Chair Leach's comments about our role here today. I'm probably the senior member on the dais this morning. I've been here for a few sessions, and I want to focus the committee and the Texas House on our role and responsibility under our Constitution. Our job is to pass laws, and we do so because we listen to the folks who elected us to come down here and make those decisions, to do the hard work, to focus on an issue, come up with the right policy, and then hopefully we'll pass that policy and it'll make a difference in people's lives. Over the years, certainly during my time here in the legislature, there was a flaw in the system. There was a flaw in the habeas corpus process. There was not a mechanism by which people could appeal to the court to grant relief in a situation where science has changed. Now, they refer to it as junk science, but I would say it's just science has changed. The knowledge has changed. And so we saw problems. So in 2013, and I think Chair Moody and Chair Leach were members of this committee at the time under Senate Bill 344, this legislature took up this issue. We said, let's create some basis of understanding that would allow relief for people who've been charged and are serving time to address the concern about changing knowledge of science. We did that. We set up steps that the Court of Criminal Appeals could look at. Well, we didn't go far enough. And 2 years later, in 2015, we revisited the issue and we changed it again. We changed the steps. And so what I would like this committee to focus in on, I'm not here to determine guilt or innocence. That's not my job. What I am here to do is, has the legislature failed in properly addressing the tenets by which the Court of Appeals can review these cases. Since the implementation of this law in 2013, there have been 74 applications for writ of habeas corpus based upon junk signs. Roughly 25 of those cases were people on death row. None of those cases have been affirmatively reviewed and remanded. None of them. The other approximately 50, 2/3 of those, about half of those have been sustained. That science has indeed changed, and so we're going to we'll allow new evidence to support a rehearing or retrial on that case. All of those cases pertain primarily to DNA analysis. We all have gotten caught up with DNA, and we understand that science, and so we recognize that has the ability to determine that the accused didn't do it, but somebody else did. But there's no cases that have been successfully appealed that take a look at the tenets for the shaken baby syndrome that we're dealing with today. Clearly, that body of evidence has changed. And so it's up to this legislative committee to look at the tenets of what's going on here. Has the Court of Appeals taken a position that is inconsistent with the statutory language that we have set out for them to follow? Are they ignoring that and saying, well, yes, it's changed, but it does not determine who the guilt or innocence? That's a level beyond which I originally envisioned in 2013 and 2015. That's a higher level. Is that a level this committee and the legislature wants the Court of Appeals to review these cases? That you actually have to have the scientific facts determine the innocence of the accused? I think not. And in this case, I think so we need to be looking, what I'm looking for with the witnesses is how are we as policymakers to look at the statute that says this is the criteria by which and the lens by which we will review the facts of this case and determine whether or not a new trial should be justified. That's what our business is. That's what our business is, not to determine guilt or innocence. It's not to argue about the death penalty. It's to determine that we as legislators have created hurdles in statute. And is the Court of Appeals following those hurdles in the spirit by which we were intending them to follow? That's what this committee is about. It's not about guilt or innocence. Guilt or innocence will be a byproduct of our hard work. Thank you, Mr. Chairman.
Chairman Darby, thank you very much. Ms. Representative Harrison.
Thank you, Chair. I want to start off by thanking everybody who's taken the time to tune in or come to this incredibly important hearing today. And I also want to start off by thanking every member of the Criminal Jurisprudence Committee for voting on a bipartisan and unanimous basis for the issuance of what was admittedly a historic and wholly unprecedented subpoena. I'm grateful for each one of you for taking such a bold action that even though it was historic and without precedent, I firmly believe it was absolutely necessary given the extenuating circumstances in this case. And without wanting to get too philosophical, I do want to remind everybody that in our country and in our state, in the great state of Texas, it is the people who write the laws that govern them. And they do that via their elected representatives in the legislature. So it is incumbent upon us to make sure that the laws that are duly enacted by the legislature are being faithfully adhered to by those who are subject to them. And so for people out there who have concerns, who have raised questions about separation of powers, I want to be unequivocally clear. If you care about the maintenance of the proper functioning of our constitutional system of separation of powers, you should be the loudest supporters and the biggest proponents of what this committee is doing here today. If the House of Representatives cannot exercise legislative oversight to make sure that our laws are not just being faithfully adhered to, but that they are not potentially being so egregiously violated that it may result in the life of a potentially innocent person being taken by the government, then I would posit there may be no matter that could be subject to legitimate legislative oversight. The role of government, ladies and gentlemen, is the protection of life and the protection of our liberties and our freedoms, which do not come from the government, but that are endowed, as our founders knew and codified in our founding documents, in an inalienable fashion, endowed to us by our Creator, and it's the central role of government to protect them. So especially when we are weighing something before us as constitutional officers of the state of Texas, where a man's life literally hangs in the balance, and we are contemplating the government exercising the ultimate and most awesome power that we give a government, and that is to take a life, we cannot get this wrong. And I say that as somebody, ladies and gentlemen, I want the state of Texas to lead the nation in just about everything. But executing potentially innocent people is not one of them. I do not want my children, and I think I can confidently say this for my colleagues on the dais here, I do not want my children to inherit a state where potentially innocent people may have their lives deprived from them by the government. So in closing, I want to just thank not just my colleagues on this committee, but every single member of the Texas House of Representatives who has spoken up and has unified and is making the conscious decision to put aside partisanship and put aside the issues that usually divide us so that we can come together in the pursuit of justice. Thank you, Chair.
Thank you, Representative. Any other members have opening remarks? Yes, Representative Bowers.
Thank you, Mr. Chairman, and I don't have much to say, but I just would like to say thank you to all the members of this committee for every bold and courageous move that was made by those here on the dais as well as those that are out in the audience. There's a higher being that knew that each of us in this room would be here today at this moment and for this time. And so I just want to say thank you all for being here. And it is historic that we are all sitting here and we are going to make some decisions that hopefully will bring positive change to the state. Thank you.
Thank you. Any other members with opening comments? Okay. Before I begin, I'm going to just let you know who the witnesses are that we'll be hearing from today. I'm going to list them in an order that I intend to call them. I want to be very clear that those things can change with schedules and logistics, but I'll go through that list now. Dr. Philip McGraw, John Grisham, the Honorable Elsa Alcala, Terry Compton, Kate Judson, Don Salzman, Dr. Natalie Montfort, and Gretchen Swine. At this time, the chair calls Dr. Philip McGraw.
Matter which one?
Choice is yours. Now, Doctor, we don't probably have the same audio capabilities that you're accustomed to. No disrespect to the House administration, but these microphones are directional, And so I want to make sure that we're able to hear you. Before I
Okay.
do turn it over to you for your testimony, I do have to do a little bit of housekeeping. I have you registered as a witness as Philip McGraw, PhD. You are here testifying on behalf of yourself, and you are testifying neutrally on the topic being considered today. Is that correct?
That is correct.
All right. Sir, I appreciate you taking the time to be here, and I don't want to belabor the point, so we'll go ahead and turn it over to you to offer your testimony. The members up here may have some questions following up after your testimony, but we look forward to hearing from you. Thank you, sir.
Well, thank you, and let me tell you, it's an honor, a privilege, and a responsibility to be here and address this committee and this important topic. And I'm here today to speak about my experience with Robert Roberson and learning about his case. And I want to talk about what I've done to be able to speak about this. I've reviewed the transcripts and supporting documents from his trial. I've done an intensive forensic interview with him, and I think I am in a position to do that because a lot of my career, decades, have been spent in the legal arena, both civil and criminal. And in terms of my training, so people know, I do have extensive training in clinical psychology and behavioral medicine or medical psychology from the great University of North Texas in their PhD program, and then I completed a postdoctoral fellowship in forensic psychology, and spent a lot of time working in the litigation arena for a big part of my professional career. And not to bury the lead, I am 100% convinced that we're facing a miscarriage of justice here. I say that because I do not believe that Mr. Roberson has had due process in this case. I do not believe he has yet enjoyed a fair trial in this matter, and I'll talk about that in detail. I believe that in the United States of America, if we are going to deprive someone of their liberty, that comes at a very high standard. If we are going to deprive someone of their life, that comes at a very high standard. A very high standard of proof, a very high standard of evidence, and when you say beyond a reasonable doubt, that's said so much that I think sometimes it can lose its meaning, and we have to really stop and think what that means. That means that if you have 12 people on a jury, that means that there should be nothing that 12 people can go in a room and reasonably disagree about. And that is a high standard, that there should not be anything that they would go in there and say, well, there's nothing here that we can reasonably disagree about. And I think that when we talk about due process and fair trial, that means that all the evidence, everything that is relevant and pertinent to that trial gets before the trier of fact, whether it be a judge or a jury, and that there's fair representation. And I certainly don't think that standard has been met here, that high standard by which we would deprive someone of their life has been met. And I think that the death penalty actually hangs in the balance here, because if we get this wrong in a case like this, I think that the death penalty
could come under real attack. And there are circumstances where I personally believe that it is appropriate. I think back to James Byrd Jr. on 6/7/98 when he was dragged by King and Brewer in Jasper, Texas, and subsequently Brewer was executed in 2011, and King was executed in 2019. A third man got life in prison. I look at cases like that and think, there are times where the death penalty just seems appropriate. And it would be I think it would be unfortunate if that was taken off the table. I'm also aware in circumstantial cases how powerful it is for an expert, a physician, for example, to come before a jury and render an opinion. And I've spent so much time in cases and debriefing jurors after a case, and know how heavily that weighs on those jurors. And I believe in this case that there was what I would refer to as triad tunnel vision, because there was a shaken baby syndrome that was defined by a triad of symptoms. And those symptoms were subdural hematoma, brain swelling, and retinal hemorrhaging. And that was believed to define the syndrome of shaken baby. And we now know from an evolution of science that that's just simply not the case. That there are a number of other explanations for those syndromes, and that causation has actually been debunked. And as a result, the Daubert test, junk science, it's just been debunked as it's no longer a standard that you can look to in defining that. And I think that once that was looked at as the order of the day, everybody got tunnel vision. And, there's something in psychology known as confirmation bias. And it's been around for a long time. Bacon first talked about it in 1889. And confirmation bias is the tendency for people to make up their mind to something, and they close off openness to alternative explanations. They seek and find and hear and process only data that supports their initial belief. And they turn a deaf ear and a blind eye to anything other than what they passionately believe to be the case. And I think we have clear evidence that that's what happened in this case. The decision was this triad of symptoms were written down, and it started with the doctors that were looking at this first, and then it trickled down to investigators and police and went right through the trial process, including Mr. Roberson's defense counsel, including his own counsel. And I've heard and read those that are opposing these efforts say that, well, this really wasn't the crux of this case. It wasn't really what was going on here. And I'm sorry, but I've studied this trial transcript, and it was the crux of this case. It was the center of this case. In one summary that I've looked at, as well, I've read a summary and I've read the actual transcript. I stopped counting at 47 times it was mentioned in the trial transcript. Shaken baby syndrome, shaken baby case, shaken baby syndrome, shaken baby case, triad of symptoms. And let me tell you something that will seem incredibly obvious, but it is not. Juries decide these things on what they see and hear, not on what they don't see and hear. And you would think, well, yeah, but my point is, I've often seen lawyers try to get something into the record and it's kept out, and heard them say, well, we didn't get that in, but the jury knows we had something really powerful, and that's going to stick with them. No, it's not. They decide on what they see and hear, not what they don't see and hear. And there was a massive amount of outcome determinative, exculpatory evidence that was never reviewed. It was never put in front of the jury. It was never heard. And you always hear, and the law is clear, that the burden of proof is on the prosecution. That Mr. Roberson does not have to prove that he didn't do this. The prosecution has to prove that he did. And that's great in theory. But having spent decades in the litigation arena, I can tell you, debriefing juror after juror after juror after juror across decades, they have taught me that they sit back and say, if we're not down here for the reason that the prosecution says we are, somebody needs to explain to me an alternative explanation. Because we know these cases get resolved 100 different ways before we ever get to this point. So if we're not down here for the reasons that they say we are, somebody needs to explain why. They're looking for an alternative explanation. And in this case, oh my gosh, was there an alternative explanation? This child was an ill baby. From 8 days old, the medical record shows this child was not well. The record shows that this baby had 46 doctor or hospital visits in her 23 months and few weeks of life. In the days leading up to her death, the record shows she had 104.5 temperature. The record shows that Robert took her to the doctor twice in the week leading up to her collapse. The record shows that she was prescribed Phenergan on 2 separate days leading up to her death. A black box warning says you do not prescribe this medication to someone under 2 years of age. On the second administration, it was Phenergan with codeine, a double impact that suppresses the respiratory system. We did not hear that this child had severe pneumonia. We did not hear that. And there were scans available to be looked at, and the medical examiner admitted that they were not looked at. And I will provide to the committee, this is a calendar of the 2 years of this child's life, and every red notation is a doctor or hospital visit during her young life. This was a child that was acutely and chronically ill. And when I say that this child had been diagnosed with interstitial pneumonia, on the left is a scan of her lungs, and the pinkish red is non-functional lung tissue, according to the doctors, and I'm telling you just what the report says. I'm not playing physician here. And on the right is a normal lung. This never got in front of a jury. Why? Because it was never looked at. It was never looked at. The medical examiner medical examiner did not review this and said so. This child had collapsed several times when Robert Roberson was not in this child's life. This wasn't the first time this child collapsed and turned blue and had respiratory shutdown. It had happened a number of times when he wasn't around. On this occasion, he was around and took the child to the hospital. So how was this case tried without all of this stuff being put into the record? It's astounding. It's astounding. Even the defense counsel, who did nothing to challenge the evidence, stipulated that this was a shaken baby case. During voir dire, I'm quoting defense counsel, every one of you related to that you had heard the term shaken baby, that it was an act of basically a lack of control of emotion. It's a bad thing, but it's not something that rises to the level of capital murder. His own counsel says this was a shaken baby case. In opening statement, his defense counsel says, this is, however, a shaken baby case. The evidence will show that Nikki did suffer injuries that are totally consistent with those applied by rotational forces, more commonly known as shaken baby syndrome. Now, Robert Roberson was offered plea deal after plea deal after plea deal and never took a plea deal because he said, I never did anything to this child. I never put my hands on this child in anger. I didn't hurt this child. I didn't do anything to this child. I'm not going to take a plea deal for something I didn't do. But yet his counsel stands up and says, more commonly known as shaken baby syndrome. On page 35 of the closing argument, defense counsel says, yes, I came here in opening and presented to you that there is responsibility in this case. Yes, this is a shaken baby case, but no, this is not a murder case. His counsel is stipulating this is shaken baby, and the science has marched on and now rebutted that shaken baby syndrome is a valid medical syndrome. Has said you cannot rely on that. That is junk science. We've now evolved to a level that says we know that shaken baby, as defined then, does not create that triad of symptoms, and that triad of symptoms can be created by a number of other things, such as over-medication, pneumonia. You could just go down the checklist here of what happened in this case. It has been reported that there was an expert psychologist that supposedly recommended to Robert, just take a plea deal, go to prison, and you can kill yourself once you're there. Now, I can't verify that. I can just tell you it's in the record and has been reported. But yet he refused those plea deals and went to trial where the jury was wrongly told that abuse could explain, that only abuse could explain the death, and they heard nothing about this child's acute or chronic illness. Now, there's another factor that comes into play here. The jury was told that Mr. Roberson was guilty because he didn't respond in an expected way at the hospital when he brought the child in. flat affect. They were not informed that he was autistic. And that did not come to light until 2018, many years later, when he had an active counsel that actually got him examined and formally diagnosed. We see all through this man's life, which was not a spotless life, let me tell you. He got involved with drugs at one point. He burgled a house at one point, violated his probation, but never is there any evidence of him being violent with other people, assaulting other people, having impulse control disorder, rage, anything of that nature. There is testimony that he was bullied because he was different and lacked social skills that are typically associated with autism, or frequently associated with autism, but he never retaliated. I sat across from Mr. Roberson at the Polunsky unit, and I've spent a lot of my professional career studying and practicing deception detection and interrogation. I've worked with law enforcement locally, federally, in developing these skills and techniques. So I didn't just go have a therapy session with him. I didn't just go talk to him. I was very mindful of deceptive behaviors, and I'm the first to say there are no lie behaviors. People talk about that like there are lie behaviors. There are not. But there are behaviors that correlate with lying. There are behaviors that show up when someone is goes into a stress mode that is associated with not telling the truth and creating something that is misdirection, trying to take you away from something they don't want you to know about them. I ask him hard questions. I ask him point blank, straight up, looking him square in the eye, did you harm this child? Did you shake this baby? Did you put your hands on this child in anger? Did you neglect this child? Did you fail to get this child to the hospital in a timely fashion? He said he had been criticized for putting the child in the car and racing to the hospital instead of calling 911 and waiting for the ambulance. He said he made the judgment call. He could get her there faster. But he was forthcoming and straightforward. It took years for specialists to put the pieces together, the pieces that the medical examiner never did. I think sometimes, with my years in the litigation arena, that sometimes we forget that the goal of prosecution is to seek justice, not conviction. I think sometimes in the heat of battle and with so much time invested in cases, that it's easy to forget that the goal is to seek justice. And if you get in the middle of a case and you determine, wait a minute, I've got the wrong person here, or I can now see that no crime was committed, that this was a case explained by medicine. This was a case explained by disease. I need to walk away from this one. And when you have a medical examiner that has admitted they never looked at the child's medical records, including the final week where there were multiple doctor visits, And even the child's last 2 days, when extraordinary efforts were made to save the child's life, which meant there were efforts made to stop the swelling and relieve the pressure in the brain, yes, there were things done to the child's head. But if you look at the pathology reports, they contradict what was concluded at the time, that there were multiple blunt force trauma to the baby's head. You look at the pathology reports, they say that's not true. There was one minor trauma to the head that would come if the baby fell out of bed. All of those things were available. And these things not being considered, that's on the state that's seeking to execute this man. And that's why I say there was not due process in this case. There were people that, in my opinion, did not do their job. No one, including me, can say with 100% certainty what happened in that house that morning. My professional opinion is that this is not a man with malice. This is not someone that hurt this child. What I can tell you that goes beyond opinion, after examining the record in this case, the trial transcript in this case, the medical records in this case, this man has not had due process. This man has not had a fair trial. And if we start executing people in Texas absent due process, absent fair trial, we are going down a really dangerous road. That is not something that I can support. And I know that has not happened. As I say, it's a very high standard to take someone's life. We must have the courage to make choices that matter at times that count, and it is always the right time to do the right thing. I welcome this committee's questions.
Doctor, thank you very much, and I appreciate your testimony. I do have a couple of follow-up questions, and then if there are other members that have questions, I'll defer to them as well. I want to focus on Robert's autism. Can you help explain the disconnect that there is between interior life and external expression? How does that present itself with someone with autism, and how does that affect a person that's in the criminal justice system?
Well, how much time do we have? Autism is not a one-dimensional disorder, and that's why it's referred to as spectrum, because there is a broad range of how autism expresses itself, and it can change across time. What we do know is that there is a difference between internal experience and external expression and interaction. And you certainly see that with Robert. I think that Robert is very flat of affect. I think he is not cognitively agile in expressing himself, and he is emotionally not well developed in terms of expressing, showing emotions, or interacting with someone on an emotional plane the way you would experience 9 out of 10 people that might not be on the spectrum. So you're not going to get a typical response from him in a crisis situation or a normal situation. And having spent 21 years on death row, which is very confining and absent a lot of the stimulation that people normally get, that's going to worsen and deepen the situation in most cases. And as I say, every situation is different. I can speak to Robert's situation in that his world has constricted, as you would think, anyone that's confined in that kind of a space. But to his credit, he has distinguished himself. And he is one of very few that has elevated himself to have some freedom to move about the pod. He has a pretty much spotless record on death row, disciplinary-wise, problem-wise. And he, as someone that is very convicted in his faith and is a strong believer, and he does have people that come and see him and visit with him. In fact, the investigator that led the prosecution efforts at the time comes and sees him on a regular basis, and he's gotten comfortable with him. And that investigator has completely changed his position, believes he made a mistake in pursuing Robert at the time, has asked his forgiveness, which Robert has graciously extended to him. And the two of them have a pretty comfortable relationship where Robert can speak to him openly. And he was much more comfortable by the time I got through talking to him than he was at the beginning. But still, he had very pushed verbalizations. He had a difficult time with eye contact. He had a difficult time relating and responding in what I would call a predictable way that you would expect with someone that was functioning absent the autistic diagnosis.
How long did you sit with him on that occasion?
They give you exactly 60 minutes, and I made sure I got every second from start to finish on a stopwatch.
How far apart were you? What was the physical?
There's
setup?
glass between us. He's on the phone and I'm on the phone, but we're maybe 3 feet between us.
You've conducted interviews over video conference?
I have, and I've conducted a number of interviews on death row with the glass between myself and the interviewee many times before.
Is that something that would have been effective in your meeting with Robert, given his condition?
It's kind of they bring him into a small room. It's probably 3 feet wide, maybe 5 feet deep, and he sits at a desk much like I'm sitting here. And the glass is kind of at the front edge of this table, and he kind of leans in on the phone. And it's kind of a comfort zone for him. I mean, he doesn't like a whole lot of stimulation, but he leans in and participates. And I ask him a variety of questions about history and what he could remember and not remember. And some things he didn't have clear memory of, and he owned that. I asked him questions to test his abstract thinking. He did not do well on those things. I challenged him when they said they wanted to go see his home where he found her and brought her in. And he said, "Sure, I'll take you right over there." And I said, "Does it strike you odd?" And there's of course a video record of this, so you can see exactly how that exchange went. But I said, "Did you feel bad? Your daughter's fighting for her life there, and they say, I want you to get in the car and take me home. Did it occur to you that I don't want to leave? I'm going to stay here with my daughter?" And he was like, "Well, that's what they told me I needed to do, so I took him home. I mean, that's what they told me to do." He's very compliant at the time. I said, "Did you want to leave?" And he's, "Well, that's what they told me to do." That's what I mean. He's a very compliant individual, and he didn't have the ability to express the emotion, "I'm not going to leave my daughter." He just complied and did what he was told.
So and that's what I was trying to drive at. And you mentioned that he had a comfort zone. So if someone like Robert's out of his comfort zone, he's got limited affect and emotional range, limited mental agility, like you said. All of those things I would think would be exacerbated if he's appearing on a screen and seeing others on a screen, as you and I learned how to do during the pandemic.
Well, yes, I think he needs every cue that he can have to grab onto and relate. You put him two-dimensional, and he doesn't, he needs cues. He needs physical feedback, and it makes it difficult if he can't have that. And his ability, we have to do everything we can to help him assist in his defense. And we can see from the trial record, 22 years ago, he didn't have a very good facility to assist in his defense at the time. If he had, even when he was there every day with his lawyer sitting next to him, if he had the ability to say, "Wait a minute, I've told you I've turned down plea deals. I don't want to do this. Why are you standing up saying this is shaken baby case?" If he had insisted that, look, this medical examiner's not talking about the evidence here. I mean, the cause of death was the child had a bacterial infection, was septicemic, and had a necrotizing infection that was eating lung tissue. If anybody here had been in that situation, we'd be saying, "Hey, we need to be talking about this. You don't need to be telling them something I've told you I didn't do. We need to be talking about an alternative explanation about why we're here." And he had a difficult time doing that when he was present at trial. If he had been on a screen, the ability to initiate contact when he's not in the room would be nil.
Okay. I have one more question for you, then I want to pass it off to my colleagues that have questions. If someone was sitting in that other chair next to you and their testimony was to this committee that this was not a shaken baby case, how would you reply to that?
Say that again.
If someone was sitting there next to you and their testimony to us was this was not a shaken baby case, how would you respond to that?
Well, I agree. It was not a shaken baby case.
Sorry, I apologize. That it was a shaken baby case.
Yeah, I was trying to figure out where you're going with this.
I apologize. That if they,
Well, first thing I would say is there's no such thing as shaken baby syndrome. Now, listen, if I'm not asking people to believe that a full-grown adult cannot pick up a 20-pound child and do serious or fatal harm to that child. Of course they can. Of course they can. They can pick that child up and bash its head into a wall or throw it on the ground or whatever. but there are going to be very clear signs of that having happened that were not present in this case. What is known as shaken baby syndrome depends on this triad of symptoms: subdural hematoma and brain swelling and retinal hemorrhaging that you see in the eyes. That triad of symptoms has been debunked. That's not what happens if a baby is shaken, and that there are a myriad of other causes, such as over-medication or absence of oxygen to the brain, or septicemia, other things that can cause those symptoms. If there are alternative explanations, then that's no longer a valid syndrome. And there have been a number of exonerations because of this. That was the science at the time. Science evolves, just like DNA technology evolved, and so there have been exonerations with DNA. The same thing here. There have been a number of shaken baby convictions that have been exonerated because they have come back with new science that says there's an alternative explanation for this. You can't convict someone on something that has now been debunked by the medical community. Even the individual who initially identified shaken baby syndrome said that was not the intent. I did not intend for that to be used as a prosecution for injury to a baby, and it has been debunked and disproven by the medical profession and is not used. So fortunately, science has progressed, medical science has progressed, and there's now new evidence available that should be used.
Well, I appreciate it. I do want to apologize for misspeaking. I was up at 3 a.m. to make a flight here today. So apologies for that.
I know you've been very busy.
But thank you I appreciate your testimony. I may have some questions following up a little bit later. But what I'm hearing from you very clearly is you've read the transcripts, you've reviewed the record, and there is not any way that someone could maintain that the state came here and said that they didn't try a shaken baby case. That's what they told us last week. No, we didn't try a shaken baby case. Sounds like you reviewed the record, and it sounds like your opinion is those facts speak loudly that is what they tried to do in that case.
Well, as I said, I stopped counting it 47 times in the record, and I read you quotes from the defense, certainly what the defense attorney tried. That was in voir dire, opening statement and closing argument, quotes from the defense attorney stipulating this was a shaken baby case, despite Robert's assertions that was not the case, and he rejected plea offers and said, I'm not going to take a plea on something I didn't do, but yet then they got up and said, well, he did do it. His own lawyer said he did do it.
Thank you. Vice Chair Cook.
Thank you, Mr. Chairman. So, Dr. Phil, before you became Dr. Phil, can you tell us a little bit more about CSI? I think you've been a little modest so far when you said you've been involved in litigation. I want you to be a little more specific about your background.
As I say, I had kind of three areas of focus: clinical, the medical psychology, and my focus in medical psychology was brain and central nervous system. And then I did a year's postdoctoral fellowship in forensic psychology, or psychology in the law. And I was a founder of a company called Courtroom Sciences, Inc. It was the original CSI. Probably should have enforced that.
I think so.
But we had a full-service trial science firm, and we were retained by clients to evaluate cases and We did strategy for cases. We assisted in jury selection, witness preparation. We often had mirror juries, shadow juries in the courtroom that matched the jury that was in the jury box, and we were able to debrief our jury. So what I'm saying is, if we had 12 jurors in the box and there's 7 women and 5 men, then we had 7 women and 5 men in the gallery that matched them. So if we had a 42-year-old woman with 2 children, a barking dog that was a Baptist with a year of college, then we had a woman out here that was 42 years old with 2 children, barking dog, a year of college that was a Baptist. Because you can't talk to the jury every night, but you can talk to your shadow jury every night, and it gives you insight to that. We mock tried cases many times before they went to actual trial to find out, how a jury in a particular venue was likely to view a case, and what was important to them and what was not important to them. The difference was at mock trial, instead of having one jury, we seated 4 or 5 or 6, and they went to independent deliberation rooms, deliberated over the actual jury charge as best we could predict what it was going to be, and all of that was videotaped and then analyzed very carefully to see what their problem-solving strategy was going to be, what was important, what was not important, so we knew what to emphasize and not emphasize. Whether this particular expert was effective or the other expert was more effective, what they wanted to hear and not wanted to hear. And we focused on telling the truth effectively and getting the best result we could. And sometimes the answer was, you need to settle.
Sure.
Thank you. And we did criminal cases and civil cases, both.
Well,
Defense and plaintiff.
as a former client from a couple of decades ago, I've seen you in action, and I can attest to your skill set. And just want to say thank you for being involved in this case. Thank you for being willing to be here today and take time out of your busy day now that you're Dr. Phil in a different role than what I knew you as a couple of decades ago. But I think I just wanted everyone to know that background. It's not like it's not the typical person talking to a few jurors. You've done this for decades, correct?
I have.
You said you read the record. Did you see discussions about a sexual assault of a child involved in the record?
I saw discussions of the sexual assault early on. It was brought up concerning 3 anal tears in the child, I believe it was. This was early on, and it seemed to me that it was brought up to prejudice the jury, frankly. But then it was dropped out later and was not part of the jury charge. It was not something they were asked to render a finding on. And it was not something that they prosecuted on at all. I felt like it was there because it's, if you want to inflame a jury panel, then you can put that into the mix. But then it was completely dropped out. It was not paid off. There was no evidence offered about it. No testimony was given about it. There was nothing in the medicals that were offered about it. It was just put in early, but then it was never paid off later.
Fair to say, if we were to grab 100 people off the street, that probably all 100 of those people would agree that that would prejudice the jury, that they heard that type of testimony prior to going to deliberation.
Well, it certainly would, and but as I say, in opening statement, you're not allowed to argue. You're just you're just going to say, we believe the evidence will show, and then the jury is expected to see, well, they made that promise. Let's see whether they bring it or they don't. And then in closing argument, the opposing attorney would be expected to say, they stood up and brought this up. Did they ever show you anything to do that? And with something that inflammatory, there's a real question about whether you even want to bring up that they didn't pay it off, because you're reminding them, and it puts it back into the juror's mind. So do you bring it up again, or do you just leave it there? It's a difficult